This webinar constitutes training for healthcare practitioners and providers using the DMOST form for use as an end-of-life document in Delaware. These are the members of the Planning Committee, and they have no financial disclosures of any type. The following are important definitions to know before beginning this training. A healthcare provider, 2503A, Section I, is any healthcare professional licensed to provide healthcare in the state of Delaware. This can include registered nurses, therapists, social workers, and medical technicians. A healthcare practitioner, 2503A, Section H, is any individual licensed to write medical orders in the state of Delaware. This includes physicians, advanced practice nurses, and physician assistants. A healthcare practitioner is the only healthcare worker that may sign a DMOST form into medical orders. Other important definitions, such as emergency care provider and healthcare institution, can be found in Section 2505A of this title. Scope of treatment, 2503A, Section N, and life-sustaining treatment, 2503A, Section J, are also definitions needed in the course of completing and executing a DMOST form. Scope of treatment is defined as any medical intervention that a patient, after consulting their healthcare practitioner, has determined are necessary and desired. Life-sustaining treatment includes any medical intervention that maintains life by sustaining, restoring, or supplanting a vital function. A patient has the right to refuse any medical treatment. Comfort measures are always provided to a patient regardless of treatment preferences. Advanced care planning is a process of communication between the patient, their family, their healthcare proxy, and medical staff. It helps to prospectively identify a surrogate decision maker for the patient, clarify the patient's treatment goals and preferences, and to help the patient develop their goals of care across their lifespan. Any adult individual with decision-making capacity has the right to refuse medical or surgical treatment in order to allow natural death, if that refusal is not contrary to existing public health laws. There are key national and local milestones that have led to the formation of DMOST. Advanced healthcare directives have been in use for over 40 years. In Delaware, an AD can consist of both a living will and a durable power of attorney for healthcare, as well as any individual instruction or power of attorney for healthcare valid in Delaware or where such document was executed. Advanced directives are not useful at the end of life because few people have them, they are difficult to apply to specific situations, and they must be translated into medical orders. In 1991, a new form called the POST, Physician Orders for Life-Sustaining Treatment form, was created in Oregon in order to solve some of the issues with advanced directives. This type of form has been found to be very effective in aligning patient preferences with the type of care they receive at the end of their life. As of May 2016, 47 states have adopted some kind of POST document. The Delaware version is called the DMOST. In 2013, citizens of the medical and legal fields came together to discuss implementing a Delaware version of the POST document. The DMOST statute was passed by Delaware legislature on May 5, 2015, and was signed into law by Governor Jack Markell on May 28, 2015. Regulations regarding DMOST were written, refined, reviewed, and entered into law, and training on DMOST began on April 1, 2016. DMOST stands for Delaware Medical Orders for Scope of Treatment. It is a voluntary form specifically for persons whose healthcare provider would not be surprised if they died within the next year. The DMOST form documents are an important conversation between the patient and their healthcare provider regarding end-of-life choices. Once signed, the DMOST form becomes medical orders that are both actionable and portable. A DMOST form is not the same as an advanced directive, although they work together to document a patient's end-of-life choices. An advanced directive is a legal document directing the future care of any individual over the age of 18, but must first be translated to be used in medical situations. While anyone over the age of 18 can complete an advanced directive, a DMOST form is specifically intended for those patients with less than a year to live and directs current medical care. The DMOST has several advantages over an advanced directive. It is portable, it becomes medical orders once signed by a healthcare practitioner, It can be initiated by an authorized representative and a provider after the patient has lost capacity, and a new form can be generated to reflect changed circumstances or decisions. There are several key public policy principles that relate to the DMOST form. They are: 1. That all adults should be encouraged to designate a decision maker and document their care goals and preferences in the event they cannot be consulted. Healthcare professionals should offer assistance in this endeavor. 2. That processes should be in place to convert a patient's goals of care and preferences regarding end-of-life care into medical orders to ensure the information is accessible and transferable across all care settings. 3. That in the absence of a validly executed advance directive, any authentic expression of an individual's goals, values, or wishes with respect to health care should be honored. 4. That electronic medical records should integrate timely information about a patient's healthcare proxy designation, their goals and preferences, and any medical orders for life-sustaining treatment. 5. That research, education, and best practice development relating to quality of care for patients with life-limiting illnesses across all care settings should be supported by federal and local governments. In order to be eligible for a DMOST form, the physician, physician assistant, or advanced practice nurse must not be surprised if the patient would die in the next 12 months. Although anyone may introduce the form, including clergy, social workers, registered nurses, lawyers, and the patient or family themselves, the only healthcare providers that may execute the DMOST and sign it into medical orders are a physician, advanced practice nurse, or physician assistant. The DMOST form is a record of a conversation between the patient and/or their authorized representative and their healthcare provider. The form may be downloaded from DelawareMost.org. We will now discuss how to fill out a DMOST form. The DMOST form obligates both healthcare providers and emergency medical personnel to honor the choices and decisions of a patient within medical standard of care indicated on the front of the document. The back of the form summarizes the instructions for completing a DMOST form. In order to be valid, the form must include the standard orders on the front of the page, the directions on the back of that same page, and the DMOST watermark must be visible. The protocol for the execution of a DMOST form has 8 steps. The healthcare provider must prepare for the discussion and begin with what the patient and family know. They should then use Ask, Talk, Ask, or some other teach-back method to provide any new information about the patient's medical condition and try to reconcile any differences that may arise in terms of prognosis, goals, hopes, or expectations. Remember to respond empathetically and use the DMOST form and questionnaire to guide a patient's choices and finalize their wishes. If the provider having the conversation with the patient is not a physician, advanced nurse practitioner, or physician assistant, they may not legally execute the DMOST form. Only a physician, APRN, or PA may execute the DMOST form and should review the form with their patient before signing. The patient must be given their original form and the questionnaire used to complete it in a pink envelope. A DMOST form does not preclude real-time shared decision-making or clinical judgment, nor should it be used until such time that a patient loses decision-making capacity. In the state of Delaware, the determination that a patient lacks decision-making capacity must be made by a physician. That determination is required if an authorized representative is executing a DMOST form on behalf of another individual. An authorized representative shall make decisions for the patient only when the patient has lost decision-making capacity. At that time, the authorized representative's decisions shall be based on the patient's previously expressed wishes, whether by advance directive or other legal document. Reliable statements previously made to family, friends, healthcare providers, or religious leaders, and taking into account the current medical state of the patient. An authorized representative may not make decisions based on a patient's status as either an individual with a pre-existing long-term mental or physical disability or an individual who is economically disadvantaged. 2504A, Section C. Executing a DMOST form is voluntary. Pursuant to 2517A, Section E, any organization that is a healthcare provider, healthcare institution, or person as defined in 102 Section 1 of Title 18, who intentionally or knowingly requires or prohibits the completion of a DMOST form or modification or revocation thereof as a condition of coverage under any policy of health or life insurance or an annuity or a public benefits program or as a condition of the provision of health care is guilty of a Class A misdemeanor for each and every act or violation, and may be subject to suspension or revocation of such person's authority to do business in Delaware. If a section of the DMOST is not completed, full treatment described in that section is assumed. Comfort measures will always be provided regardless of treatment choices. The patient or their representative must be given a plain language explanation of the DMOST form in the form of the DMOST FAQs. This is required by law. Section A is not medical orders. In this section, the patient's goals, wishes, and values are discussed and may be written down to help guide treatment choices in the event the patient is unable to communicate. The DMOST conversation and execution should be viewed as informed consent for the medical procedures and treatments used at the end of life. The patient must be fully informed of what these treatments and/or procedures entail, as well as what complications may ensue. The treatment options in Section B allow the patient to choose between cardiopulmonary resuscitation, CPR, and do not resuscitate, DNR, if they are found with no pulse and are not breathing. In this section, providers should discuss CPR survival rates and possible complications of advanced cardiac life support procedures. That is, admission to the intensive care unit, use of mechanical breathing or electrical shock, broken ribs due to chest compressions, etc. In Section C, medical interventions such as dialysis, chemotherapy, and blood transfusions should be discussed. A DMOST form must be internally consistent. If a patient chooses CPR in Section B, they must choose full treatment in Section C. This is because hospitals, emergency transport, and other medical institutions will use full advanced cardiac life support guidelines when resuscitating a patient. These ACLS guidelines are considered full treatment. A provider should also discuss the location of these treatments and procedures with their patient. If a patient does not wish to enter the ICU, he or she should not choose full treatment in this section. Trial periods of full treatment may be selected if a patient wishes, but these options must be carefully explained to the patient. If a trial period is requested, these orders may be indicated on the Other Orders line. A DMOST form is considered invalid if it is not internally consistent. If CPR is selected in Section B, full treatment must be selected in Section C. However, any treatment option may be selected if a patient chooses DNR in Section B. The selection of full treatment and DNR indicates that a patient wishes all medical procedures and treatments be done to extend their life up until such time that they are found not breathing and without a pulse. Section D discusses artificial nutrition and hydration. Patients must be made aware that hydration and nutrition by mouth will always be offered first if feasible. Additionally, healthcare providers must explain IVs, nasogastric tubes, and PEG tubes when assisting patients with this section. Patients may choose no artificial hydration or nutrition, hydration only, or both options. There is also the option of a trial period for artificial hydration and/or nutrition. Section E indicates the patient's authorized representative. An authorized representative must have the authority to make decisions with respect to the patient's healthcare preferences if and only if that patient lacks the capacity to do so. The authorized representative must be 1. An individual designated by the patient under an advanced healthcare directive. 2. An agent under a medical durable power of attorney for healthcare decisions. 3. A guardian of the person appointed by the Delaware Court of Chancery, Title 12, 39, and 39A. 4. A surrogate appointed by the Surrogacy Statute 2507. 5. An individual who is otherwise authorized under applicable law to make healthcare decisions on the patient's behalf. 2503A, Section L. If a patient does not wish for their DMOST form or decisions to be changed once they have lost decision-making capacity, they have the option of signing their name to that effect in Section E. Section E also contains contact information for the healthcare provider assisting the patient with filling out a DMOST form correctly. Both the patient or their authorized representative and the healthcare practitioner executing the DMOST form must sign in Section F for the form to be valid. The patient or authorized representative must sign first. If the authorized representative is executing a DMOST form on behalf of a patient, the medical record must document that a physician has determined the patient's incapacity and the authorized representative's authority. Once the practitioner, a physician, advanced practice nurse, or physician assistant, signs the form, it immediately becomes medical orders, so the practitioner should review the form with the patient, checking for any inconsistencies before signing. A DMOST form may not be modified by any initials or markings on the form. If a patient wishes to change or revise their DMOST form, the old form must be voided and a new form must be created. This allows for an additional conversation between the healthcare provider and the patient or authorized representative and any modifications to the goals the patient may have for their healthcare. The DMOST form may be voided and a new one created with any change in circumstances. Pursuant to 2517A, a healthcare provider who fails to act in accordance with the requirements of this chapter is subject to discipline for professional misconduct. A healthcare institution that intentionally fails to act in accordance with the requirements of this chapter shall be liable for a civil penalty of not more than $1,000 for each offense. An emergency care provider subject to regulation by the department who intentionally fails to act in accordance with the requirements of this chapter is subject to such disciplinary measures as the Secretary of Department deems necessary and consistent with the department's statutory authority. An individual will be guilty of a Class G felony if they knowingly or intentionally 1. Conceal, cancel, deface, obliterate, or withhold personal knowledge of a completed DMOST form or a modification or revocation thereof without the patient's consent, or if the patient lacks decision-making capacity, without the consent of the patient's authorized representative. 2. Falsify or forge a completed DMOST form or a modification or revocation thereof. Or 3. Coerce or fraudulently induce the completion of a DMOST form or a modification or revocation thereof by a patient, or if the patient lacks decision-making capacity, by a patient's authorized representative. Pursuant to 2515A, a healthcare institution, practitioner, or provider acting in good faith and in accordance with generally accepted healthcare standards is not subject to civil or criminal penalties for complying with the DMOST form signed by a practitioner appearing to have authority to execute a DMOST, declining to comply with a DMOST based on the belief the healthcare practitioner lacked the authority to execute a DMOST at the time of execution, assuming a DMOST form was valid and has not been voided or modified, and complying with said form, providing life-sustaining treatment in an emergency situation without knowing of the existence of a DMOST form, declining to comply with a DMOST form because the form is contrary to the conscience or good faith medical judgment of the practitioner or written policies of the institution. A DMOST form, as well as any advance directive, does not preclude real-time shared decision-making or clinical judgment. The form and the authorized representative's ability to make healthcare decisions do not go into effect until such time as the patient loses decision-making capacity as determined by a physician. 2518A, Section B. The DMOST should be recognized in all healthcare settings, and policies should be in place to recognize, honor, and store these forms. The original DMOST form must travel with the patient across all healthcare settings in the provided pink envelope. Copying the form is discouraged as it requires the healthcare institution or provider to inquire about the existence of a more recent version. All healthcare institutions should have policies in place to inquire of the existence of a DMOST form, and if a current form is the most recent version, every time a patient changes healthcare settings. DMOST forms and advance directives follow the last-in-time rule. Therefore, policies should also be in place to suggest updating all of a patient's end-of-life documents in the same time frame to better honor the patient's wishes. The DMOST plain language frequently asked questions must be given to patients upon completion of the form. It is required by law that the DMOST plain language FAQs must be given to the patient upon execution of a DMOST form. The provider completing or executing the DMOST must be familiar with the FAQs so they can answer any questions that may arise. The DMOST form is a voluntary, standardized, and portable medical order in the state of Delaware. It is used to inform patients of end-of-life treatment options they may be asked to consider. The DMOST form is portable medical orders that must be followed by any healthcare provider, practitioner, or institution in the state of Delaware. This form is indicative of a conversation between a patient, their authorized representative, and either a physician, nurse practitioner, or physician assistant regarding the patient's wishes for end-of-life treatment and procedures that may be necessary. The DMOST is only appropriate for those people whose healthcare practitioner would not be surprised if they died within the next year. The DMOST form can only be executed by a physician, advanced practice nurse, or physician assistant. Once signed, the form becomes portable medical orders and is immediately applicable. All healthcare practitioners, healthcare providers, healthcare institutions, and emergency care providers in the state of Delaware must treat a patient who has a completed DMOST form in accordance with the directions and options indicated on that form. A DMOST form, along with advance directives and powers of attorney for healthcare, are only consulted when a patient has lost decision-making capacity. This capacity determination must be made by a physician. Unless otherwise indicated by Section E of a previous DMOST form, a patient's authorized representative may sign and execute a new DMOST form on behalf of that patient. The DMOST form does not change a decision maker designated by another advance directive or court appointment. A patient or authorized representative may void a DMOST at any time, and new one may or may not be executed at their discretion. If a patient wishes to make changes to their DMOST form, the old form must be voided and a new form must be executed. DMOST forms and advance directives follow the last-in-time rule. Filling out the DMOST form is a voluntary action and may be stopped or voided at any time. No healthcare provider, practitioner, nor institution may require a patient to complete a DMOST form for any reason. Once the form has been signed by a physician, advanced practice nurse, or physician assistant, it immediately becomes medical orders and will be followed by all healthcare providers, practitioners, and institutions. DMOST reciprocity is assumed in the states bordering Delaware. 2510A states that a document executed in another state that meets either DMOST requirements or the requirements of that state shall be deemed valid to the same extent as a DMOST form. The DMOST checklist helps to document and verify the DMOST process and should be completed alongside the DMOST form. It should travel with the DMOST form and with the patient in the pink DMOST envelope. Providers, practitioners, and institutions are encouraged to make a copy of the checklist for their records.